Searches and Seizures, Rule 126. Nature of a search warrant, Bar 1994. 1. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court, Section 1. 2. A search warrant is not a criminal action nor does it represent a commencement of a criminal prosecution even if it is entitled like a criminal action. It is not a proceeding against a person but is solely for the discovery and to get possession of personal property. It is a special and peculiar remedy, drastic in nature, and made necessary because of public necessity. It resembles in some respects with what is commonly known as John Doe proceedings. A search warrant is a legal process which has been likened to a writ of discovery employed by the state to procure relevant evidence of a crime. It is in the nature of a criminal process restricted to cases of public prosecutions. A search warrant is a police weapon, issued under the police power. It has no relation to a civil process. It is not a process for adjudicating civil rights or maintaining mere private rights. It concerns the public at large as distinguished from ordinary civil action involving the rights of private persons and may only be applied for the furtherance of public prosecutions. 3. The power to issue search warrants is exclusively vested with the trial judges in the exercise of their judicial functions. The constitutional provision. 1. Like an arrest, the laws and rules governing a search warrant is based upon constitutional guarantees. The pertinent constitutional provision provides. Section 2, the right of the people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. 1987 Constitution of the Philippines. 2. The following provision solidifies the constitutional prohibition against unreasonable searches and seizures by providing for an exclusionary rule, thus. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. 1987 Constitution of the Philippines. Arrest distinguished from search and seizure. 1. The rules on arrest are concerned with the seizure of a person. It involves the taking of a person in custody. A search may follow an arrest but the search must be incident to a lawful arrest. The rules on searches and seizures cover a wider spectrum of matters on the search of both persons and places and the seizure of things found therein. 2. A probable cause to arrest does not necessarily involve a probable cause to search and vice versa. Probable cause to arrest involves a different determination from probable cause to search. In order to determine probable cause to arrest, the judge, not the prosecutor, must have sufficient facts in his hands that would tend to show that a crime has been committed and that a particular person committed it. Probable cause to search requires facts to show that particular things connected with a crime are found in a specific location. 3. The judge is not necessarily required to make a personal examination before issuing a warrant of arrest. The judge must, before issuing the search warrant, personally examine the complainant and the witnesses he may produce in determining probable cause. 4. An arrest may be made on any day and at any time of the day or night. A search warrant is generally served in the daytime, unless there be a direction in the warrant that it may be served at any time of the day or night. Definition of a search warrant under the rules. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Application for a search warrant, where to file. 1. As a rule, an application for a search warrant shall be filed before any court within whose territorial jurisdiction a crime was committed. 2. There are exceptions to the above general rule. These are: a. The application may be made before any court within the judicial region where the crime was committed if the place of the commission of the crime is known. b. The application may also be filed before any court within the judicial region where the warrant shall be enforced. Note: in both exceptions, filing in such courts requires compelling reason stated in the application. c. The application shall be made only in the court where the criminal action is pending, if the criminal action has already been filed. Search warrants involving heinous crimes and others. 1. The above rules in Section 2 have been deemed modified by AM number 99-2009 SC dated January 25, 2000, in cases involving heinous crimes, illegal gambling, dangerous drugs and illegal possession of firearms. Under the aforementioned issuance by the Supreme Court, the following are authorized to act on all applications for search warrants involving any of the above crimes. The Executive Judge and Vice Executive Judges of Regional Trial Courts of Manila and Quezon City filed by the Philippine National Police, the National Bureau of Investigation, the Presidential Anti-Organized Crime Task Force and the Reaction Against Crime Task Force with the Regional Trial Courts of Manila and Quezon City. The application shall be personally endorsed by the heads of said agencies, for the search of places to be particularly described therein, and the seizure of property or things as prescribed in the rules of court, and to issue the warrants of arrest, if justified, which may be served in places outside the territorial jurisdiction of said courts. The authorized judges shall keep a special docket book listing the details of the applications and the results of the searches and seizures made pursuant to the warrants issued. 2. In Spouses Marama v. People, the petitioners filed a motion to quash the search warrant and to suppress the evidence illegally seized. It was contended among others, that the application for search warrant was filed and the warrant was issued by the RTC of Manila, which is a court outside the territorial jurisdiction and judicial region of the courts of Angeles City and Porac, Pampanga, where the alleged crime was committed. It was also argued that the application for search warrant was not personally endorsed by the head of the NBI as required by AM number 99-1009-80. The Supreme Court observed that the cases against petitioners involved a violation of the Dangerous Drugs Law of 1972. As such, the application for search warrant may be filed by the NBI in the city of Manila and the warrant issued may be served outside of Manila pursuant to AM number 99-1009 SC. The court likewise held that as to the claim that the application for the warrant was defective for not having been personally endorsed by the head of the NBI, the court held that nothing in AM number 99-1009 SC prohibits the head of the NBI and of the other law enforcement agencies mentioned from delegating their ministerial duty of endorsing the application to their assistant heads. Besides, under Section 31, Chapter 6, Book 4 of the Administrative Code of 1987, an assistant head or other subordinate in every bureau may perform such duties as may be specified by their superior or head, as long as it is not inconsistent with law. Ex parte application for a search warrant. An application for a search warrant is heard ex parte. It is neither a trial nor a part of the trial. Action on these applications must be expedited, for time is of the essence. Great reliance has to be accorded by the judge to the testimonies under oath of the complainant and the witnesses. Property subject of a search warrant. 1. The property subject of a search warrant is personal property, not real property. A search warrant may be issued not only for the search but also for the seizure of the following. A. Personal property subject of the offense. B. Personal property stolen or embezzled and other proceeds, or fruits of the offense, or C. Personal property used or intended to be used as a means of committing an offense. 2. The rule is, only the personal properties described in the search warrant may be seized by the authorities. In People v. Nunez, search warrant number 42 specifically authorized the taking of shabu and paraphernalia only. By the principle of a jus dem generis, the court explained, where a statute describes things of a particular class or kind accompanied by words of a generic character, the generic word will usually be limited to things of a similar nature with those particularly enumerated, unless there be something in the context of the statement which would repel such inference. Certainly, the lady's wallet, cash, grinder, camera, component, speakers, electric planer, jigsaw, electric tester, saws, hammer, drill, and bolo were not encompassed by the word paraphernalia, as they bear no relation to the use or manufacture of drugs. In seizing the said items then, the police officers exercised their own discretion and determined for themselves which items in appellant's residence they believed were proceeds of the crime or means of committing the offense. This, said the court, is absolutely impermissible. In the same case, the court declared, The purpose of the constitutional requirement that the articles to be seized be particularly described in the warrant is to limit the things to be taken to those, and only those particularly described in the search warrant, to leave the officers of the law with no discretion regarding what articles they should seize. A search warrant is not a sweeping authority empowering a raiding party to undertake a fishing expedition to confiscate any and all kinds of evidence or articles relating to a crime. Accordingly, the objects taken which were not specified in the search warrant should be restored to appellant. Requisites for the issuance of a search warrant. 1. The following are the requisites for a search warrant under the rules of court. A. There must be probable cause in connection with one specific offense. B. The presence of probable cause is to be determined by the judge personally. C. The determination by the judge must be made after an examination under oath or affirmation of the complainant and the witnesses he may produce. D. The warrant must specifically describe the place to be searched and the things to be seized, which may be anywhere in the Philippines. 2. The absence of the following requisites for a search warrant's validity will cause its downright nullification. 1. It must be issued upon probable cause. 2. The probable cause must be determined by the judge himself and not by the applicant or any other person. 3. In the determination of probable cause, the judge must examine, under oath or affirmation, the complainant and such witnesses as the latter may produce. And 4. The warrant issued must particularly describe the place to be searched and persons or things to be seized. 3. Inherent in the court's power to issue search warrants is the power to quash warrants already issued. After a judge has issued a warrant, he is not precluded to subsequently quash the same, if he finds upon re-evaluation of the evidence that no probable cause exists. Probable cause in search warrants. A search warrant can be issued only upon a finding of probable cause. Probable cause for search warrant means such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place to be searched. The facts and circumstances being referred thereto pertain to facts, data or information personally known to the applicant and the witnesses he may present. The applicant or his witnesses must have personal knowledge of the circumstances surrounding the commission of the offense being complained of. Reliable information is insufficient. Mere affidavits are not enough, and the judge must depose in writing the complainant and his witnesses, because in the determination of probable cause, the court must resolve whether or not an offense exists to justify the issuance of the search warrant. Probable cause does not mean actual and positive cause, nor does it import absolute certainty. The determination of the existence of probable cause is not concerned with the question of whether the offense charged has been or is being committed in fact, or whether the accused is guilty or innocent, but only whether the affiant has reasonable grounds for his belief. The requirement is less than certainty of proof, but more than suspicion or possibility. 3. There is no general formula or fixed rule for the determination of probable cause, since the same must be decided in light of the conditions obtaining in given situations, and its existence depends to a large degree upon the findings or opinion of the judge conducting the examination. It is presumed that a judicial function has been regularly performed, absent a showing to the contrary. A magistrate's determination of a probable cause for the issuance of a search warrant is paid with great deference by a reviewing court, as long as there was substantial basis for that determination. Although the term probable cause has been said to have a well-defined meaning under the law, the term is exceedingly difficult to define with any degree of precision, and one which would cover every state of facts which may arise. As to what acts constitute probable cause, there is no exact test. The question whether or not probable cause exists is one which must be decided in the light of the conditions obtaining in given situations. 4. One case gives a reminder by declaring that probable cause is a flexible, common-sense standard. It merely requires that the facts available to the officer would warrant a man of reasonable caution and belief that certain items may be contraband or stolen property or useful as evidence of a crime. It does not require proof that such belief be correct or more likely than true. A practical, non-traditional probability that incriminating evidence is involved is all that is required. 5. Since probable cause is dependent largely on the opinion and findings of the judge who conducted the examination and who had the opportunity to question the applicant and his witnesses, the findings of the judge deserves great weight. The reviewing court can overturn such findings only upon proof that the judge disregarded the facts before him or ignored the clear dictates of reason. However, the probable cause must also be shown to be within the personal knowledge of the complainant or the witnesses he may produce and not based on mere hearsay. In determining its existence, the examining magistrate must make a probing and not merely routine or pro forma examination of the complainant and the witnesses. In determining probable cause, the oath required must refer to the truth of the facts within the personal knowledge of the applicant or his witnesses, because the purpose thereof is to convince the magistrate, not the individual making the affidavit and seeking the issuance of the warrant, of the existence of probable cause. 6. In a case, the trial court retracted its earlier finding of probable cause because the seized items were accordingly incomplete or insufficient to charge petitioner with a criminal offense, thus, negating its previous determination of probable cause. The court disagreed because in quashing the search warrant, it would appear that the trial court had raised the standard of probable cause to whether there was sufficient cause to hold petitioner for trial. In so doing, the trial court committed grave abuse of discretion. Probable cause for a search warrant is defined as such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place sought to be searched. A finding of probable cause needs only to rest on evidence showing that, more likely than not, a crime has been committed and that it was committed by the accused. Probable cause demands more than bare suspicion, it requires less than evidence which would justify conviction. The existence depends to a large degree upon the finding or opinion of the judge conducting the examination. However, the findings of the judge should not disregard the facts before him nor run counter to the clear dictates of reason. Probable cause to arrest and probable cause to search. A probable cause to arrest does not necessarily involve a probable cause to search and vice versa. Probable cause to arrest involves a different determination from probable cause to search. In order to determine probable cause to arrest, the judge, not the prosecutor, must have sufficient facts in his hands that would tend to show that a crime has been committed and that a particular person committed it. Probable cause to search requires facts to show that particular things connected with a crime are found in a specific location. Webb v. De Leon, expounds. Each requires a showing of probabilities as to somewhat different facts and circumstances, and thus one can exist without the other. In such cases, two conclusions must be supported by substantial evidence, that the items sought are in fact seizable by virtue of being connected to criminal activity, and that the items will be found in the place to be searched. It is not also necessary that a particular person be implicated. By comparison, in arrest cases there must be probable cause that a crime was committed and that the person to be arrested has committed it, which of course can exist without any showing that evidence of the crime will be found at the premises under a person's control. Worthy of note, our rules of court do not provide for a similar procedure to be followed in the issuance of a warrant of arrest and search warrants. How the examination shall be conducted by the judge. 1. Aside from the requirements mandated by Section 4 of Rule 126, the rule requires the judge to comply with a specific procedure in the conduct of the examination of the complainant and the witnesses he may produce. The required procedure involves the following. A. The examination must be personally conducted by the judge. B. The examination must be in the form of searching questions and answers. C. The complainant and the witnesses shall be examined on those facts personally known to them. D. The statements must be in writing and under oath, and E. The sworn statements of the complainant and the witnesses, together with the affidavits submitted, shall be attached to the record. 2. The facts and circumstances to be testified to by the complainant and the witnesses he may produce, being referred thereto, pertain to facts, data or information personally known to the applicant and the witnesses he may present. The applicant or his witnesses must have personal knowledge of the circumstances surrounding the commission of the offense being complained of. Reliable information is insufficient. Mere affidavits are not enough, and the judge must depose in writing the complainant and his witnesses. An application for a search warrant if based on hearsay cannot, standing alone, justify issuance of a search warrant. It is necessary for the witnesses themselves, by their own personal information, to establish the applicant's claims. 3. Section 5 of Rule 126 of the Revised Rules on Criminal Procedure, prescribes the rules in the examination of the complainant and his witnesses when applying for search warrant, to wit. Section 5, Examination of Complainant, Record. The judge must, before issuing the warrant, personally examine in the form of searching questions and answers, in writing under oath, the complainant and the witnesses he may produce on facts personally known to them and attach to the record their sworn statements, together with the affidavits submitted. The foregoing provisions require that the judge must, before issuing the warrant, make a personal examination under oath of the complainant and the witnesses he may produce in accordance with Section 5 of Rule 126. Mere affidavits of the complainant and his witnesses are thus not sufficient. Aside from the examination under oath, the examining judge has to make searching questions and elicit answers of the complainant and the witnesses he may produce in writing and to attach them to the record. Thus, in Ballin v. Denapal, the court found an RTC judge guilty of gross ignorance of the law for failure to observe the mandate of the rules because the court found that there was no record of searching questions and answers attached to the records of the case. 4. The searching questions propounded to the applicant and the witnesses depend largely on the discretion of the judge. Although there is no hard and fast rule governing how a judge should conduct his investigation, it is axiomatic that the examination must be probing and exhaustive, not merely routinary, general, peripheral, perfunctory or pro forma. The judge must not simply rehash the contents of the affidavit but must make his own inquiry on the intent and justification of the application. 5. In the determination of probable cause, the Constitution and the rules of court require an examination of the witnesses under oath. The examination must be probing and exhaustive, not merely routine or pro forma. The examining magistrate must not simply rehash the contents of the affidavit but must make his own inquiry on the intent and justification of the application. Asking of leading questions to the deponent in an application for search warrant, and conducting of examination in a general manner, would not satisfy the requirements for issuance of a valid search warrant. Particular description of place or person. 1. The long-standing rule is that a description of the place to be searched is sufficient if the officer with the warrant can, with reasonable effort, ascertain and identify the place intended and distinguish it from other places in the community. Any designation or description that points out the place to the exclusion of all others, and on inquiry leads the officers unerringly to it, satisfies the constitutional requirement. Moreover, in the determination of whether a search warrant describes the premises to be searched with sufficient particularity, it has been held that the executing officer's prior knowledge as to the place intended in the warrant is relevant. This would seem to be especially true where the executing officer is the affiant on whose affidavit the warrant had been issued, and when he knows that the judge who issued the warrant intended the compound described in the affidavit. The standard for determining the legality of a warrant directed against a person is whether the person has been sufficiently described with particularity sufficient to identify him with reasonable certainty. Even if his name is unknown or erroneously written, the description of the person with certainty to identify him and set him apart from others is enough to lend validity to the warrant. Nowhere in Section 4, Rule 126 or any other provision of the revised Rules of Criminal Procedure is it required that the search warrant must name the person who occupies the described premises. 2. The determining factor as to whether a search warrant describes the premises to be searched with sufficient particularity is not whether the description is technically accurate in every detail but rather whether the description is sufficient to enable the officer to locate and identify the premises with reasonable effort, and whether there is any reasonable probability that another premises may be mistakenly searched and not the one intended to be searched under the warrant. The prevailing doctrine is that the warrant must sufficiently describe the premises to be searched so that the officer executing the warrant may, with reasonable effort, ascertain and identify the place intended. 3. In United States v. Staransburg, the warrant as well as the affidavit supporting it gave an erroneous street address but with the right apartment number in a four-building apartment complex. Since there was no other apartment in the entire complex that had the same apartment number as that described in the warrant, the description was upheld. The court, in a California case, applying the same principle, sustained the validity of a warrant which gave the wrong lot number or address but referred to the house to be searched as that one occupied by the accused. 4. In another American case, the place to be searched was described as 313 West 27th Street, a dwelling. The apartment of Melvin Lloyd Manley. The place was actually a multi-occupancy dwelling with subunits or individual apartments. The defendant assailed the validity of the warrant on the ground that his apartment or unit was not sufficiently described. Here the court ruled that a search warrant directed against a multiple occupancy structure, although does not specify the subunit to be searched, would not be considered invalid where it adequately specifies the name of the occupant of the subunit against which the warrant is directed and thus provides the searching officers sufficient information to identify the place intended by the warrant. The warrant, said the court, must make reasonably clear what place is to be searched. Where the particular place to be searched is described by the affidavit of the officer as a single living unit in an entire building, a warrant describing an entire building and thus authorizing the search of the building is too broad. 5. In People v. Estrada, a building had 4 apartments, and one of them located on the second floor was occupied by the accused. The warrant referred to the apartment house occupied by Manuel Estrada at 18 South 19th Street, San Jose, the second story of a White House. The court ruled that by referring to Estrada, the warrant identified the particular unit to be searched and the warrant was not overly broad. Estrada further held that if the description in the warrant limits the search to a particular part of the premises either by a designation of the area or other physical characteristics of such part or by a designation of its occupants, the business conducted there, the warrant will meet constitutional standards in respect to the description of the place to searched. Particular description of the items to be seized, General Warrants, Bar 2005. 1. The provision requiring a particular description of the items or things to be seized is designed to prevent general searches and avoid the seizure of a thing not described in the warrant, and also so nothing is to be left to the discretion of the officer executing the warrant. The requirement of particularity is designed to prevent general exploratory searches which reasonably interfere with a person's right to privacy. Warrants which do not describe the things to be seized with the required particularity have been traditionally called general warrants. 2. The requirement of particularity is said to be satisfied if the warrant imposes a meaningful restriction upon the objects to be seized. A meaningful restriction is one that leaves nothing to the discretion of the officer who conducts the search. Corollarily, a warrant may not authorize a search broader than the facts supporting its issuance. Hence, a warrant authorizing the search and seizure of papers showing or tending to show the trafficking of cocaine is invalid because the affidavit supporting the issuance made no reference to the existence of such papers. 3. The Philippine Supreme Court declares that the purpose of this requirement is to limit the things to be seized to those described in the search warrant and to leave the officers of the law no discretion regarding what articles they shall seize so abuses may not be committed. 4. The common denominator among decisions on particularity regard descriptions of a generic nature as failing to impose a meaningful restriction on the officer conducting the search. Descriptions of the things to be searched and seized as stolen goods, obscene materials, or other articles of merchandise too numerous to mention, have been held inadequate. The phrase, any and all other stolen items was impermissibly vague. In People v. Docago, the officers had information about certain unique markings of stolen cigarettes, but the description did not include the markings to permit the officers to differentiate the object of the search from those which were not stolen. The words, cigarettes and any and all goods, were deemed inadequate. 5. In a leading Philippine case, a warrant was deemed illegal, thus. Books of accounts, financial records, vouchers, journals, correspondence, receipts, ledgers, portfolios, credit journals, typewriters, and other documents and papers showing all business transactions, including disbursement receipts, balance sheets and related profits and loss statements is too broad and general because it authorizes the search and seizure of records pertaining to all business transactions of petitioner herein, regardless of whether the transactions were legal or illegal. 6. Also held inadequate for constitutional compliance is the following description of the things to be searched and seized. Television sets, video cassette recorders, rewinders, tape head cleaners, accessories, equipment and other machines used or intended to be used in the unlawful reproduction, sale, rental lease, distribution of the above-mentioned videotapes which she is keeping and concealing in the premises above described. 20th Century Fox Film Corporation v. Court of Appeals. The above articles and appliances, said the court, are generally connected with or related to a legitimate business not necessarily involving piracy of intellectual property or infringement of copyright laws. Including them without particularity makes the search warrant too general, which could result in the confiscation of all items found in any video store. 7. A high degree of particularity is required for items such as books, films, recordings, or other materials that have not yet been adjudged obscene. Since these materials are at this stage still deemed to be constitutionally protected, the requirement of particular description must be accorded the most scrupulous exactitude, and when the bases for their seizure are the ideas which they contain. 8. Some decisions in the United States have sometimes allowed a general description when specificity is difficult and where technical description would have required the experience of a trained surgeon. For instance, the following description for purposes of a warrant was upheld: various instruments and tools in performing abortion, which were instrumentalities of such offense. In People v. Schmidt, the court allowed a description reading, marijuana ... dangerous drugs, stimulant drugs and hallucinogenics ... together with such vessels, implements, furniture in which drugs are found, and the vessels, implements and furniture used in connection with the manufacture, production and dispensing of such drugs. In United States v. Apolloni, 761 F. 2d 520, 9th Sir. 1985, the validity of the following description of gambling paraphernalia was allowed: wagering paraphernalia such as betting slips, bottom sheets and O-sheets, and journals and schedules of sporting events. A warrant describing the property to be seized as deer or elk meat illegally possessed was considered adequate because a more particular description was not possible. The meat to be seized had no brand names or serial numbers. 9. In the Philippines, general descriptions have likewise been allowed in some cases when dictated by the nature of the things to be seized, on the theory that the description must be specific insofar as the circumstances will ordinarily allow. The law does not require that the things to be seized must be described in precise and minute details as to leave no room for doubt on the part of the searching authorities. But the use of a generic term or a general description in a warrant is allowed only when a more specific description of the things to be seized is not available. Thus, the mere use of terms like multiple set books of accounts, ledgers, journals, columnar books, cash register books, sales books or records and similar general descriptions, is unacceptable considering the circumstances where the petitioner is alleged to have committed tax fraud and smuggling. The issuing judge could have formed a more specific description of the documents because he was furnished copies of the documents sought to be seized. As regards the terms unregistered delivery receipts and unregistered purchase and sales invoices, these need not be identified specifically. It is not possible to do so considering these are unregistered. Taking into consideration the nature of the articles described, no other more adequate and detailed description could have been given because of the difficulty in describing the contents of the same. 10. In Co v. McClendall, the petitioners claimed that the search warrants issued were general warrants prohibited by the Constitution because the things to be seized were not described and specified. One warrant, for instance, directing the search and seizure of firearms, did not list the firearms to be seized and were not classified as to size, make, caliber. The subject warrant merely stated unlicensed firearms of various calibers and ammunitions for the said firearms. In brushing aside the contention of the petitioner, the court observed that the law enforcement officers could not have been in the position to know beforehand the exact caliber or make of the firearms to be seized. In the process of surveillance conducted at a distance, they had no way of knowing the caliber and make of the firearms unless they get a close view of the weapons, and thus could not be expected to know the detailed particulars of the objects to be seized, including the communications equipment. The court likewise considered the use of the words and the like of no moment and did not make the warrants in question general warrants. Ownership of property seized not required. The law does not require that the property to be seized should be owned by the person against whom the search warrant is directed. It is sufficient that the person against whom the warrant is directed has control and possession of the property sought to be seized. In an American decision involving a search of newspaper offices, the U.S. Supreme Court ruled that a search warrant is directed to the seizure of things and not the seizure of persons, and hence, the critical element is not ownership but whether there is a reasonable cause to believe that the things to be seized are located in the place to be searched. Extent of the search. 1. A fair reading of jurisprudence discloses that the reasonableness of both the seizure and the search does not exclusively refer to the manner by which the warrant was procured. It refers also to the reasonableness of the manner the warrant was executed, including the time and place of its execution. Also, for the search to be reasonable, the object of the search must be the one properly described in the warrant. Marin v. United States, in holding that officers cannot seize property not specified in the warrant, found that a search warrant describing only intoxicating liquor should not include ledgers and bills of account within the searched premises. Where the warrant is unambiguous and limited only to a particular place like a store described in the warrant, the search does not extend to the apartment units located at the back of the store even if the sketch submitted to the judge include the apartments. It is neither fair nor licit to allow officers to search a place not described in the warrant because the place not described is what the officers had in mind. 2. A warrant which authorizes the search of weapons includes the authority to open closets, drawers, chests and containers in which the weapons might be found. These containers must give way to the interest in the prompt and efficient completion of the task when a legitimate search is underway and when its purpose and limits have been precisely defined. If the warrant is to search a vehicle, every part of that vehicle which may contain the object to be seized may be searched. In other words, the lawful search of the premises particularly described extends to the areas in which the object may be found. 3. It has been held that when a search warrant authorizes the search of a place particularly described, a justified search would include all the things attached to or annexed to the land if the place described be land. Courts have also generally allowed a search of vehicles owned or controlled by the owner of the premises and at the same time found in the premises. Search of third persons not named in the warrant. 1. Assume that a search warrant for a described place of a named owner is being executed. May a person who just happens to be in the premises be also searched? The prevailing American general rule is that a warrant to search a place does not extend to the authority to search all persons in the place because the police have no probable cause to search and detain a person not particularized in the warrant. Thus, in Ibarra v. Illinois, the U.S. Supreme Court struck down as invalid a search of a mere patron in a bar. 2. There have been cases where the court upheld the search of things belonging to third persons while in the place validly searched, as when the officers had no knowledge that the same belongs to a third person. Issuance and form of the search warrant. The warrant shall be issued when the judge is satisfied of the existence of facts upon which the application is based or that there is a probable cause to believe that they exist. The form of the search warrant must be substantially in the form prescribed by the rules. Duration of the validity of a search warrant. A search warrant shall be valid for 10 days from its date. Thereafter, it shall be void. Time of making the search. The warrant shall be served in the daytime and such fact must be so directed by the warrant. However, if the affidavit asserts that the property is on the person or in the place ordered to be searched, the warrant may insert a direction that it may be served at any time of the day or night. The rule on issuance of search warrants allows for the exercise of judicial discretion in fixing the time within which the warrant may be served, subject to the statutory requirement fixing the maximum time for the execution of a warrant. Manner of making the search. 1. The search shall be made in the presence of the lawful occupant of the house, room or any other premises, or any member of the lawful occupant's family. In the absence of the latter, the search shall be made in the presence of 2 witnesses of sufficient age and discretion residing in the same locality. The rule in this regard is emphatic. No search shall be made except in the presence of the persons mentioned in the rules. 2. In Panungsha v. People, the petitioner assailed the validity of the search which was allegedly conducted while she was not in the house. The petitioner alleges that since the search warrant was defective, the items seized during the search could not be used in evidence against her. The court categorically ruled that even assuming that the petitioner or any lawful occupant of the house was not present when the search was conducted, the search was done in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality. Clearly, the requirements of Section 8 were complied with by the police authorities who conducted the search. Section 8, Rule 126 of the Rules of Court provides: search of house, room, or premises, to be made in presence of 2 witnesses. No search of a house, room, or any other premise shall be made except in the presence of the lawful occupant thereof or any member of his family or in the absence of the latter. 2 witnesses of sufficient age and discretion residing in the same locality. 3. The officer seizing the property must give a detailed receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. Rule: if the officer is refused admittance, knock and announce. Rule 1. Being armed with a warrant does not justify outright entry or barging into the place to be searched. An officer should knock, introduce himself and announce his purpose, and only in exceptional cases may he forego the same, like when his safety is in danger of being jeopardized or when evidence is about to be destroyed. 2. The officer may break open any outer or inner door or window of a house or any part of a house or anything therein, provided the following requisites are complied with. A. The officer gives notice of his purpose and authority. B. He is refused admittance to the place of directed search despite the notice, and C. The purpose of breaking is to execute the warrant or to liberate himself or any person lawfully aiding him when unlawfully detained therein. Duties of the officer after the search and seizure, delivery and inventory. A. The officer must forthwith deliver the property seized to the judge who issued the warrant. B. The officer must, together with the delivery of the property, also deliver a true inventory of the property seized. Such inventory must be duly verified under oath. C. Note: a violation of the above rule shall constitute contempt of court. Duty of the judge, return and other proceedings. 1. Under Section 12b of Rule 126, the judge issuing the search warrant has the following duties. A. The judge who issued the warrant shall ascertain if the return has been made. He shall do so 10 days after issuance of the search warrant. B. If no return has been made, the judge shall summon the person to whom the warrant was issued and require him to explain why no return was made. C. If the return has been made, the judge shall ascertain whether Section 11 of Rule 126, giving of a receipt for the property seized, was complied with, and shall require that the property seized be delivered to him. The judge shall also see to it that subsection of Section 12 of Rule 126, delivery of the property seized and true inventory, has been complied with. 2. A judge should know that his duty as a magistrate does not end when the warrant is issued. When the evidence shows that the judge who issued the search warrant did not require the officers executing the warrant to make an accurate and complete inventory of the things seized and submit the same to him, he is guilty of gross ignorance of the law. 3. In Santos v. Price cases, the court found that the Court of Appeals, in reversing the order of the trial court granting the motion to quash, erred in ordering the return of the seized items to respondent. The court held that Section 12, Rule 126 of the Revised Rules of Criminal Procedure expressly mandates the delivery of the seized items to the judge who issued the search warrant to be kept in custodia legis in anticipation of the criminal proceedings against petitioner. The delivery of the items seized to the court which issued the warrant, together with a true and accurate inventory thereof, duly verified under oath, is mandatory in order to preclude the substitution of said items by interested parties. The judge who issued the search warrant is mandated to ensure compliance with the requirements for 1. The issuance of a detailed receipt for the property received. 2. Delivery of the seized property to the court, together with 3. A verified true inventory of the items seized. Any violation of the foregoing constitutes contempt of court. Duty of the custodian of the logbook. 1. The return on the search warrant shall be filed and kept by the custodian of the logbook on search warrants, who shall enter therein the date of the return, the result, and other actions of the judge. A violation of the above rule shall constitute contempt of court. Objection to issuance or service of a warrant. 1. Any objection concerning the issuance or service of a warrant or a procedure in the acquisition by the court of jurisdiction over the person of the accused must be made before he enters his plea, otherwise, the objection is deemed waived. 2. The constitutional right of appellant against warrantless arrest and search was not violated when the appellant failed to assail the legality of the arrest and the seizure of the sachet of shabu prior to arraignment or at any stage in the proceedings of the trial court. The arrest was pursuant to a buy-bust operation, which is a valid form of entrapment of felons and the execution of their criminal plan, and that the search conducted on appellant was incidental to a lawful arrest. Where to file a motion to quash a search warrant or to suppress evidence. 1. A motion to quash a search warrant and or to suppress evidence obtained by virtue of the warrant may be filed and acted upon only by the court where the action has been instituted. 2. If no criminal action has been instituted, the motion may be filed in and resolved by the court that issued the search warrant. However, if such court failed to resolve the motion and a criminal case is subsequently filed in another court, the motion shall be resolved by the latter court. Who may assail the issuance of a search warrant? 1. Well settled is the rule that the legality of a seizure can be contested only by the party whose rights have been impaired thereby, and the objection to an unlawful search and seizure is purely personal and cannot be availed of by third parties. 2. The manager of an establishment is a real party in interest to seek the quashal of the search warrant for the obvious reason that the search warrant, in which the manager was solely named as respondent, was directed against the premises and articles over which he had control and supervision. The manager, who is at the same time the petitioner, was directly prejudiced or injured by the seizure of the gas tanks because petitioner was directly accountable as manager to the purported owner of the seized items. When the application for a search warrant averred that petitioner had in his possession and control the items subject of the alleged criminal offense, the interest of the manager, petitioner becomes obvious. The corporation does not have the exclusive right to question the seizure of items belonging to the corporation on the ground that the latter has a personality distinct from the officers and shareholders of the corporation. Assuming arguendo that the corporation was the owner of the seized items, petitioner, as its manager, had the authority to question the seizure of the items belonging to the corporation. Unlike natural persons, corporations may perform physical actions only through properly delegated individuals, namely, their officers and or agents. Petition for certiorari for unwarranted quashal of a search warrant. In one case, after issuing a search warrant, the RTC of Iloilo made a turnaround and granted the motion to quash filed by the petitioner. The RTC likewise issued an order for the return of the items seized to the petitioner. After a denial of its motion for reconsideration, the respondent elevated the matter to the Court of Appeals via a special civil action for certiorari, arguing that the trial court committed grave abuse of discretion in quashing the search warrant. The petition essentially questioned the quashal of the search warrant despite a prior finding of probable cause. The Court of Appeals rendered a decision setting aside the orders of the lower court. The petitioner sought reconsideration but was denied. One of the issues raised in the subsequent petition for review on certiorari before the Supreme Court was whether or not the petition for certiorari filed with the Court of Appeals by respondent was the proper remedy to assail the orders of the trial court. The court held that the special civil action for certiorari was the proper recourse availed by respondent in assailing the quashal of the search warrant. An unwarranted reversal of an earlier finding of probable cause constituted grave abuse of discretion. In any case, the court had allowed even direct recourse to the court or to the Court of Appeals via a special civil action for certiorari from a trial court's quashal of a search warrant. Exceptions to the search warrant requirement, bar 1988, 1995, 1996, 1997, 2008. 1. As a general rule, the procurement of a warrant is required before a law enforcer can validly search or seize the person, house, papers, or effects of any individual. To underscore the significance the law attaches to the fundamental right of an individual against unreasonable searches and seizures, the Constitution clearly declares in Section 3(2), Article 3, that any evidence obtained in violation of this or the preceding section shall be inadmissible in evidence for any purpose in any proceeding. Bar 1998. Thus, the 1987 Constitution states that a search and consequent seizure must be carried out with a judicial warrant, otherwise, it becomes unreasonable and any evidence obtained therefrom shall be inadmissible for any purpose in any proceeding. People v. Racho. 2. There are however, instances when securing a warrant before effecting a search and a seizure would not serve the ends of an orderly society. The time and effort required to secure a warrant may sometimes actually frustrate the effective enforcement of the laws and encourage criminal activities. On the other hand, the rule requiring a warrant protects citizens from the overzealousness of law enforcement officers who hold as personal dogma that the means justify the end. To harmonize these conflicting perspectives, Courts have developed certain exceptions to the warrant requirement in order to authorize warrantless searches and seizures with the end of striking out a balance between the need to safeguard the rights of citizens and the need to avoid emasculating the powers of the state to maintain a well-ordered society. Although embedded within the rule on search warrants is the general rule that searches and seizures shall be valid only when carried out by virtue of a search warrant, this rule, however, is subject to certain judicially formulated exceptions. 3. It has always been recognized that the rule requiring a warrant is not, however, absolute. There are well-recognized instances where searches and seizures are allowed even without a valid warrant under any of the following circumstance. A. Warrantless search incidental to a lawful arrest. B. Seizure of evidence in plain view. Bar 2008. The elements of the plain view exception are, a prior valid intrusion based on the valid warrantless arrest in which the police are legally present in the pursuit of their official duties, b. The evidence was inadvertently discovered by the police who have the right to be where they are, c. The evidence must be immediately apparent, and d. Plain view justified mere seizure of evidence without further search. C. Search of a moving vehicle, highly regulated by the government. The vehicle's inherent mobility reduces expectation of privacy, especially when its transit in public thoroughfares furnishes a highly reasonable suspicion amounting to probable cause that the occupant committed a criminal activity. D. Consented warrantless search. E. Customs search. F. Stop-and-frisk or Terry searches, bar 1995. G. Exigent and emergency circumstances. H. Search of vessels and aircraft, and I. Inspection of buildings and other premises for the enforcement of fire, sanitary and building regulations. 4. In the exceptional instances where a warrant is not necessary to effect a valid search or seizure, what constitutes a reasonable or unreasonable search or seizure is purely a judicial question, determinable from the uniqueness of the circumstances involved, including the purpose of the search or seizure, the presence or absence of probable cause, the manner in which the search and seizure was made, the place or thing searched, and the character of the articles procured. Search incident to a lawful arrest, bar 2003. 1. The search incident to a lawful arrest exception is authorized by Section 13, which provides. Section 13. A person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. 2. The application of the above rule presupposes that the person searched was previously arrested lawfully. Hence, a person illegally arrested cannot be validly searched without a warrant under this provision. For an arrest to be lawful, the arrest may either be by virtue of a warrant lawfully procured or by virtue of a warrantless arrest authorized under Section 5 and other applicable provisions such as Section 13 of the same rule. 3. Recent court pronouncements hold that in searches incident to a lawful arrest, the arrest must precede the search. Generally, the process cannot be reversed. Nevertheless, a search substantially contemporaneous with an arrest can precede the arrest if the police have probable cause to make the arrest at the outset of the search. Thus, we have to determine first whether the police officers had probable cause to arrest appellant. If what prompted the police to apprehend the accused, even without a warrant, was the tip given by the informant that appellant would arrive carrying shabu, this circumstance gives rise to another question of whether that information, by itself, is sufficient probable cause to effect a valid warrantless arrest. The long-standing rule in this jurisdiction is that reliable information alone is not sufficient to justify a warrantless arrest. The rule requires, in addition, that the accused perform some overt act that would indicate that he has committed, is actually committing, or is attempting to commit an offense. There is no cogent reason to depart from this well-established doctrine. Parameters of a search incident to a lawful arrest. Immediate possession and control rule. 1. Section 13 of Rule 126 specifically enumerates the allowable scope of a search incident to a lawful arrest. The provision limits the search to the following. A. For dangerous weapons. B. For anything which may have been used in the commission of an offense, or C. For anything which constitute proof in the commission of an offense. 2. Is the search confined to the search of the person lawfully arrested? How about the search of the premises where he was arrested? The phraseology of Section 13 of Rule 126, at first glance, suggests that it is only the person lawfully arrested who is to be searched. The provision partly reads, "A person lawfully arrested may be searched." 3. The court has however, ruled on several occasions that, when an arrest is made, it is reasonable for the arresting officer to search the person arrested in order to remove any weapon that the latter might use in order to resist arrest or effect his escape. Otherwise, the officer's safety might well be endangered, and the arrest itself frustrated. In addition, it is entirely reasonable for the arresting officer to search for and seize any evidence on the arrestee's person in order to prevent its concealment or destruction. Moreover, in lawful arrests, it becomes both the duty and the right of the arresting officer to conduct a warrantless search not only on the person of the suspect but also within the permissible area within the latter *8 reach. A valid arrest allows the seizure of evidence or dangerous weapons either on the person of the one arrested or within the area of his immediate control. The phrase "within the area of his immediate control" means the area from within which he might gain possession of a weapon or destructible evidence. A gun on a table or in the drawer in front of the person arrested can be as dangerous to the arresting officer as one concealed in the clothing of the person arrested. 30. Thus, when the person arrested was brought out of the room with his hands tied, a cabinet which is locked could no longer be considered as part of an area within his immediate control because there was no way for him to take any weapon or to destroy any evidence that could be used against him. 4. A search and a seizure incident to a lawful arrest is not limited to things related to the reason for the arrest. If for instance, a person is legally arrested for illegal possession of drugs, the search is not confined to things used in the commission of the crime. To protect the arresting officer, the search extends to weapons like a gun or a knife with no actual connection to the crime of illegal possession of the drugs. If in the course of the search, evidence is found constituting proof of another offense, like an illegally possessed weapon, it's submitted that the phraseology of the rule does not prevent the seizure of the evidence. The provisions of Section 13 of Rule 126 are consistent with the ruling in Adams v. Williams, that a person arrested may be searched for weapons and all unlawful articles in his person and within his immediate control may be seized. American decisions categorically declare that an arresting officer may seize evidence of crimes other than the crime which was the reason for the arrest. In one case, the accused was arrested pursuant to a warrant for possession and transportation of explosives, but during the search there was discovered an item the possession of which is illegal. The discovery of objects unrelated to the arrest does not render the seizure invalid. 5. Section 13 of Rule 126 allows the warrantless search of the person lawfully arrested as an incident to a lawful arrest in a manner similar to American rulings allowing a full search of the body of the person. The cases of United States v. Robinson allowed the search of the cigarette case of a person arrested for a traffic violation. Illegal drugs were discovered in both instances. A full search means searching any property associated with the arrestee's body like clothing, jewelry, watches and others attached to the person in a permanent or semi-permanent capacity. The search includes inspecting the clothing of the person arrested for bloodstains, fingerprints or even serial numbers. Other cases have similarly held that the right without a search warrant to contemporaneously search persons lawfully arrested and to search the place where the arrest is made to find and seize things connected with the crime as its fruits or by the means it was committed, as well as weapons and other things to escape from custody is not to be. But while the U.S. Supreme Court had broadened the search from the person to the place, such place should be one where the arrest was made. The house, for instance, where the arrest was made may be searched when such searches and seizures naturally appertain to and attend such arrests. Thus, in Marin v. United States, the court ruled that because the officers had made a valid search and arrest in the premises, they had a right without a warrant to contemporaneously search the place for evidence of the criminal enterprise. In Marin, the court suggested that the search should be confined to the offender's immediate possession and control, a concept made clearer in Chime v. California. But the right does not extend to other places such as a house several blocks away from the place where an arrest was made. In this case, the search would no longer be incident to a lawful arrest. 6. In Chime v. California, the U.S. Supreme Court discussed the extent of a search incident to a lawful arrest. In this case, the police officers, armed with an arrest warrant but not a search warrant, were admitted to petitioner's home by his wife, where they awaited petitioner's arrival. When he entered, he was served with the warrant. Although he denied the officer's request to look around, They conducted a search of the entire house on the basis of the lawful arrest. The officers looked through the entire house including the attic, the garage and a small workshop. At petitioner's trial on burglary charges, items taken from his home were admitted over the objection that they had been unconstitutionally seized. His conviction was affirmed by the California appellate courts, which held, despite their acceptance of petitioner's contention that the arrest warrant was invalid, that, since the arresting officers had procured the warrant in good faith, and since, in any event, they had sufficient information to constitute probable cause for the arrest was lawful. The courts also held that the search was justified as incident to a valid arrest. The U.S. Supreme Court found the search of the entire house unreasonable. It categorically ruled in Chime that assuming the arrest was valid, the warrantless search of petitioner's house cannot be constitutionally justified as an incident to that arrest. An arresting officer may search the arrestee's person to discover and remove weapons and to seize evidence to prevent its concealment or destruction, and may search the area within the immediate control of the person arrested, meaning the area from which he might gain possession of a weapon or destructible evidence. For the routine search of rooms other than that in which an arrest occurs, or for searching desk drawers or other closed or concealed areas in that room itself, absent well-recognized exceptions, a search warrant is required. A reasonable distinction is to be made between a search of the person arrested and the area within his reach and immediate control on one hand and more extensive searches in other areas on the other. The ruling in Chime clarified previous cases which made vague references to the search of areas considered to be in the possession and control of the person arrested, allowing searches of places not necessarily within the actual physical control of a person but within his constructive control and giving free rein to law enforcers in determining what to be searched. Chime limited the search to the arrestee's person and within his immediate control. Thus, following Chime, the arresting officers validly seized 2 revolvers within the reach of the person arrested for being involved in an armed robbery. 7. The Chime tradition found expression, for instance, in the Philippine case of People v. Seizure. Here Seizure was arrested at the NAIA for bringing heroin into the country. Later, the persons involved in the smuggling of heroin were arrested in the hotel room of Seizure in an entrapment operation. Questioning of the persons arrested disclosed that one of them was occupying a room in the same hotel where Seizure was billeted. Without a search warrant, the other room was searched and incriminating evidence was seized. Clearly, said the court, citing Chime, the search of the latter room was illegal and the evidence obtained therein is inadmissible, the place searched being not within the immediate control of the person arrested. 8. In a leading Philippine case, Nolasco v. Patio, the accused who were at large for rebellion and subversion, were arrested by constabulary officers at the intersection of 2 streets in Quezon City at 11:30 a.m. on the same day at 12:00 noon. Another team of officers searched the house of one of the accused under a warrant procured earlier in the day. After charges were filed against one of the accused for illegal possession of subversive documents, a motion to suppress the evidence obtained from the search of the house was filed. The motion was anchored on the alleged void character of the search warrant for its failure to particularly describe the things to be seized and for lack of searching questions propounded to the applicant's witnesses. The Supreme Court held the warrant void in a later proceeding but did not order the return of the items confiscated because the search of the house could have accordingly been validly effected even without a warrant. Accordingly, considering that the accused has been charged with rebellion, which is a crime against public order, the warrant for her arrest not having been served for a considerable period of time, and the search having been made just within half an hour after her arrest, we are of the opinion, said the court, that the search did not need a search warrant. This, for possible effective results in the interest of public order. What must be considered according to the court is the balancing of the individual's right to privacy and the public's interest in the prevention of crime and the apprehension of criminals. To the majority pronouncement which justified a warrantless search as an incident to a lawful arrest, a dissenting opinion was interposed by Justice Tihaki, calling the majority decision patently against the constitutional prescription and settled law and jurisprudence. While the rules of court allows a warrantless search of a person who is lawfully arrested, the rule, in the opinion of Justice Tihaki, is limited to his person at the time of and incident to his arrest and to dangerous weapons or anything which may be used as proof of the commission of the offense. Such warrantless search obviously cannot be made in a place other than the place of arrest. To hold that her dwelling could be searched without a warrant is to sanction an untenable violation, if not nullification, of the cited basic constitutional rights against unreasonable searches and seizures. Justice Cuevas and Justice Abad Santos likewise lodged strong dissents. Justice Cuevas, with whom Justice Tehankee concurred, on his part opined that the lawful arrest justifying the validity of the warrantless search must be limited to and circumscribed by the subject, time and place of the arrest. As to subject, the warrantless search is sanctioned only with respect to the person of the suspect, and things that may be seized from him are limited to dangerous weapons or anything which may be used as proof for the commission of the offense. With respect to the time and place of the warrantless search, it must be contemporaneous with the lawful arrest. To be valid, it must have been conducted at about the time of the arrest or immediately thereafter and only at the place where the suspect was arrested. Justice Cuevas added, in addition to a lawful arrest, the search must be incident to the arrest and the search must be made at the place of the arrest, otherwise it is not incident to the arrest. Acting on a partial motion for reconsideration of the court's decision, the court reconsidered and ordered the return of the items seized to the petitioner. In doing so, the court adopted the rationale and the dissent of Justice Tehankee, Nolasco v. Spano. 9. Spano v. Court of Appeals, is one of the cases which drives home the point on the concept of a search incident to a lawful arrest. Here, police officers arrested the accused in flagrante delicto selling marijuana in a street corner. The search of his person yielded 2 cellophane bags of marijuana. When asked if he had more, he admitted he had marijuana in his house. The policeman then proceeded to the house of the accused and made a search which yielded 10 more cellophane tea bags of marijuana. The court held that the articles seized from the accused during his arrest were valid under the doctrine of a search made incidental to a lawful arrest. The search may extend beyond the person of the person arrested to include the premises or surroundings under his immediate control. The warrantless search, however, of the house of the accused which yielded marijuana became unlawful since the police officers were not armed with a search warrant at the time. Moreover, the house of the accused was beyond his reach and control. 10. Earlier in People v. Lua, a similar pronouncement was made by the court. The accused in Lua was arrested outside his house in flagrante delicto in a buy-bust operation. The court found nothing objectionable in the body search of the person arrested and the confiscation of the bags of marijuana and a Paltic revolver in his person. However, the subsequent search of the house of the arrestee was found invalid and the marijuana found therein considered inadmissible. The search of the house according to the court is not within the contemplation of a search incident to a lawful arrest. The house, at the time of his arrest, was not within the reach and control of the arrestee. Searches of moving vehicles. 1. A warrantless search of a moving vehicle is justified on the ground that it is not practicable to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought. 2. When a vehicle is flagged down and subjected to an extensive search, such a warrantless search has been held to be valid as long as the officers conducting the search have reasonable or probable cause to believe prior to the search that they would find the instrumentality or evidence pertaining to a crime in the vehicle to be searched. 3. Nevertheless, the exception from securing a search warrant when it comes to moving vehicles does not give the police authorities unbridled discretion to conduct a warrantless search of an automobile. To do so would render the aforementioned constitutional stipulations innumerable and expose the citizenry to indiscriminate police distrust which could amount to outright harassment. Surely, the policy consideration behind the exemption of search of moving vehicles does not encompass such arbitrariness on the part of the police authorities. In recognition of the possible abuse, jurisprudence dictates that at all times, it is required that probable cause exist in order to justify the warrantless search of a vehicle. Checkpoints. 1. In the famous case of Valmondi v. Davila, the court declared that nowhere in its decision did the court legalize all checkpoints, that is at all times and under all circumstances, and what it declared was that the checkpoints are not illegal per se. The court went on to hold that under exceptional circumstances, as where the survival of organized government is on the balance, or where the lives and safety of the people are in grave peril, checkpoints may be allowed and installed by the government. Implicit in this proposition is, that when the situation clears and such grave perils are removed, checkpoints will have absolutely no reason to remain, XXX for as long as the vehicle is neither searched nor its occupants subjected to a body search, and the inspection of the vehicle is limited to a visual search, said routine checks cannot be regarded as violative of an individual's right against unreasonable search. Citing American jurisprudence, the court added that routine checks, when conducted in a fixed area, are even less intrusive and are permissible. Routine checkpoint stops do not intrude similarly on the motoring public. Also, automobiles, because of their mobility, may be searched without a warrant upon facts not justifying a warrantless search of a residence or office. Brinegar v. United States, 338 U.S. 160, 93 liters ed. 1879, 69 South Court 1302, 1949, Carroll v. United States, 267 U.S. 132, 69 liters ed. 543,45 S. Court 280,39 ALR 790, 1925. The cases so holding have, however, always insisted that the officers conducting the search have reasonable or probable cause to believe that they will find the instrumentality of a crime or evidence pertaining to a crime before they begin their warrantless search. Valmondi v. Davila, GR number 83988, May 24, 1990. 2. Searches conducted in checkpoints are valid for as long as they are warranted by exigencies of public order and are conducted in a way least intrusive to motorists. For as long as the vehicle is neither searched nor its occupants subjected to a body search, and the inspection of a vehicle is limited to a visual search, said routine checks cannot be regarded as violative of an individual's right against unreasonable searches. People v. Vicario, GR number 141137, January 20, 2004, 420 script 280. 3. A more recent case affirming Davila and Vicario holds that not all checkpoints are illegal. Those which are warranted by the exigencies of public order and are conducted in a way least intrusive to motorists are allowed. 4. Admittedly, routine checkpoints do intrude, to a certain extent, on motorists' right to free passage without interruption, but it cannot be denied that, as a rule, it involves only a brief detention of travelers during which the vehicle's occupants are required to answer a brief question or two. For as long as the vehicle is neither searched nor its occupants subjected to a body search, and the inspection of the vehicle is limited to a visual search, said routine checks cannot be regarded as violative of an individual's right against unreasonable search. In fact, these routine checks, when conducted in a fixed area, are even less intrusive. Buy-bust operations, warrant not needed, Bar 2003. 1. A buy-bust operation is a form of entrapment legally employed by peace officers as an effective way of apprehending drug dealers in the act of committing an offense. This police operation has judicial sanction as long as it is carried out with due respect to constitutional and legal safeguards, although there are no rigid or textbook methods on the right or proper way of conducting such operations. 2. A search warrant or warrant of arrest is not needed in a buy-bust operation because here the accused is caught in flagranti delicto. It catches the violator in flagranti delicto, and the police officers conducting the operation are not only authorized but duty-bound to apprehend the violator and to search him for anything that may have been part of or used in the commission of the crime. Similar pronouncements have been made in other cases. Hence, it was ruled that an arrest made after an entrapment operation does not require a warrant. Such warrantless arrest is considered reasonable and valid under Section 5A. When an arrest is made during an entrapment operation, it is not required that a warrant be secured in line with the provisions of Section 5A, allowing warrantless arrests. Under the said rule, a peace officer or private person may, without a warrant, arrest a person when, in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. 3. In one case where the accused assailed the validity of a buy-bust operations, it was ruled that from the very nature of a buy-bust operation, the absence of a warrant does not make the arrest illegal. The illegal drug seized is not the fruit of the poisonous tree as the defense alleges. The seizure made by the buy-bust team falls under a search incidental to a lawful arrest. Since the buy-bust operation was established as legitimate, it follows that the search was also valid, and a warrant was likewise not needed to conduct it. Entrapment and instigation. 1. Entrapment is the employment of such ways and means for the purpose of trapping or capturing a lawbreaker. On the other hand, Instigation is the means by which the accused is lured into the commission of the offense charged in order to prosecute him. One form of entrapment is the buy-bust operation. It is legal and has been proved to be an effective method of apprehending drug peddlers, provided due regard to constitutional and legal safeguards is undertaken. 2. Instigation means luring the accused into a crime that he, otherwise, had no intention to commit, in order to prosecute him. On the other hand, entrapment is the employment of ways and means in order to trap or capture a lawbreaker. Instigation presupposes that the criminal intent to commit an offense originated from the inducer and not the accused, who had no intention to commit the crime and would not have committed it were it not for the initiatives by the inducer. In entrapment, the criminal intent or design to commit the offense charged originates in the mind of the accused. The law enforcement officials merely facilitate the apprehension of the criminal by employing ruses and schemes. In instigation, the law enforcers act as active co-principals. Instigation leads to the acquittal of the accused, while entrapment does not bar prosecution and conviction. In the Philippines, entrapment is not a defense available to the accused. It is instigation that is available as a defense and is an absolutory cause. Applicable tests in a buy-bust operation. Adoption of the objective test. 1. There is no rigid or textbook method in conducting a buy-bust operation. However, in determining the occurrence of entrapment, two tests have been developed, the subjective test and the objective test. 2. Under the subjective view of entrapment, the focus is on the intent or predisposition of the accused to commit a crime. Under the objective view, on the other hand, the primary focus is on the particular conduct of law enforcement officials or their agents, and the accused's predisposition become irrelevant. The Government Agents Act is evaluated in the light of the standard of conduct exercised by reasonable persons generally and whether such conduct falls below the acceptable standard for the fair and honorable administration of justice. 3. It appears that Philippine courts have leaned towards the adoption of the objective test in upholding the validity of a buy-bust operation. In People v. Storia, the court stressed that, in applying the objective test, the details of the purported transaction during the buy-bust operation must be clearly and adequately shown, that is, the initial contact between the poser or buyer and the pusher, the offer to purchase, and the promise or payment of the consideration until the consummation of the sale by the delivery of the illegal drug subject of the sale. It is further emphasized that the manner by which the initial contact was made, whether or not through an informant, the offer to purchase the drug, the payment of the buy-bust money, and the delivery of the illegal drug, whether to the informant alone or the police officer, must be subject of strict scrutiny by courts to ensure that law-abiding citizens are not unlawfully induced to commit an offense. 4. The objective test in buy-bust operations demands that the details of the purported transaction must be clearly and adequately shown. This must start from the initial contact between the poser or buyer and the pusher, the offer to purchase, the promise or payment of the consideration until the consummation of the sale by the delivery of the illegal drug subject of the sale. The manner by which the initial contact was made, whether or not through an informant, the offer to purchase the drug, the payment of the buy-bust money, and the delivery of the illegal drug, whether to the informant alone or the police officer, must be the subject of strict scrutiny by courts to ensure that law-abiding citizens are not unlawfully induced to commit an offense. Criminals must be caught but not at all cost. At the same time, however, examining the conduct of the police should not disable courts into ignoring the accused's predisposition to commit the crime. If there is overwhelming evidence of habitual delinquency, recidivism or plain criminal proclivity, then this must also be considered. Courts should look at all factors to determine the predisposition of an accused to commit an offense insofar as they are relevant to determine the validity of the defense of inducement. Effect of absence of prior surveillance before a buy-bust operation. 1. Owing to the special circumstances surrounding the drug trade, a buy-bust operation can be carried out after a long period of planning, but no rule requires a prior surveillance of the suspected offender before conducting a buy-bust operation. In People v. Concepcion, the court explained that the absence of a prior surveillance or test buy does not affect the legality of the buy-bust operation. There is no textbook method of conducting buy-bust operations. The court has left to the discretion of police authorities the selection of effective means to apprehend drug dealers. A prior surveillance, much less a lengthy one, is not necessary, especially where the police operatives are accompanied by their informant during the entrapment, Flexibility is a trait of good police work. Also, the failure of the operatives to record the boodle money will not render the buy-bust operation illegal. The recording of marked money used in a buy-bust operation is not one of the elements for the prosecution of sale of illegal drugs. The recording or non-recording thereof in an official record will not necessarily lead to an acquittal as long as the sale of the prohibited drug is adequately proven. 2. Quinnicut v. People also declares that a prior surveillance, much less a lengthy one, is not necessary, especially where the police operatives are accompanied by their informant during the entrapment. Flexibility is a trait of good police work, and that when time is of the essence, the police may dispense with the need for prior surveillance. Effect of absence of record in police blotter. In relation to prosecution for illicit drugs, the non-recording of the buy-bust money in the police blotter will not affect the validity of the operations. Neither law nor jurisprudence requires that the buy-bust money be entered in the police blotter. The non-recording of the buy-bust operation and buy-bust money in the police blotter is not essential, since they are not elements in the illegal sale of dangerous drugs. The only elements necessary to consummate the crime is proof that the illicit transaction took place, coupled with the presentation in court of the dangerous drug seized as evidence. Plain View Doctrine, Bar 2007, 2008. 1. A theoretical example could illustrate the principle particularly well. For instance, a policeman flags down a car for a traffic violation. When the officer approaches the car, he sees in the front seat of the car a submachine gun and 2 hand grenades, items not normally issued to civilians. After a few inquiries and having determined the absence of a license for the items, the officer now has a reasonable ground to seize the object without a warrant. Also, assume that an officer goes to a residence to execute a warrant to search a house for particularly described stolen antique images. As the officers look around in the living room of the house, they see on a table plastic sachets containing crystalline substances, which based on their training and experience are illegal drugs. Since the illegal drugs are in plain view, seizing them would not be an invalid warrantless seizure. 2. Under the plain view doctrine, objects falling in the plain view of an officer who has a right to be in the position to have that view are subject to seizure and may be presented as evidence. The plain view doctrine applies when the following requisites concur. 1. The law enforcement officer in search of the evidence has a prior justification for an intrusion or is in a position from which he can view a particular area. 2. The discovery of the evidence in plain view is inadvertent. And, 3. It is immediately apparent to the officer that the item he observes may be evidence of a crime, contraband or otherwise subject to seizure. Stated in another way, the plain view doctrine permits an officer, while lawfully engaged in an activity and lawfully present in a particular place, to seize an apparently illicit object without first obtaining a warrant authorizing him to do so. It is founded on a common-sense rule that when a police officer has seen or observed an object in plain view, to require the officer to secure a warrant would be to engage in a needless exercise because failure to seize the object once observed might involve danger to the public and to the officer. The rule allows a law enforcement officer to make a seizure without obtaining a search warrant if evidence of criminal activity or the product of a crime can be seen without entry or search. As the U.S. Supreme Court said in Katz v. U.S., whatever a person knowingly exposes to public view, even in their own home or office, is not private. In the context of searches and seizures, the principle provides that objects perceptible by an officer who is rightfully in a position to observe them can be seized without a search warrant and are admissible as evidence. 3. In one case, the police authorities were in the area because that was where they caught up with petitioner after the chase. They saw the firearms inside the vehicle when petitioner opened the door. Since a shooting incident just took place and it was reported that petitioner was involved in the incident, it was apparent to the police officers that the firearms may be evidence of a crime. Hence, they were justified in seizing the firearms. 4. In another case, the police were investigating a reported homicide. The police looked into the car of the accused and from the window they saw a pillowcase, backseat and a briefcase, all covered with blood. The police secured a warrant to search the car. In the course of enforcing the warrant, they saw inside the car a blood-soaked sock and a floor mat. They took the things. The accused assailed the validity of the taking of the items that have been illegally taken since they were not mentioned in the affidavit supporting the application for the warrant. The court ruled that the seizure was constitutional. The items seized were in plain view found during a search supported by a warrant. 5. Foreign cases have frequently given as an example of the applicability of the plain view doctrine, a situation in which the police have a warrant to search a given area for specified objects, and in the course of the search come across some other article of incriminating character. 6. The doctrine has been applied to a situation where the police officers inadvertently come across evidence while in hot pursuit of a fleeing suspect. The doctrine has also been applied when an incriminating object comes into view during a search incident to a lawful arrest and thus, could be searched without a warrant. 7. The plain view doctrine has been applied where a police officer is not searching for evidence against the accused, but nonetheless inadvertently comes across an incriminating object. Where the object seized was inside a closed package, the object itself is not in plain view and therefore cannot be seized without a warrant. If the package is such that an experienced observer could infer from its appearance that it contains the prohibited article, then the article is deemed in plain view. 8. The fact that the evidence is in plain view is not alone sufficient to justify a warrantless seizure. American courts which have extensively discussed the principle have held that the seizure be based also on the immediately apparent element. This means that the officer must have probable cause to believe that the object is evidence of a crime. Probable cause exists when the facts and circumstances within the officer's knowledge and of which he had reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that the object is evidence of a crime. Not only must the item be in plain view, its incriminating character must also be immediately apparent. This principle has also been followed in Philippine decisions. 9. The principle is well illustrated in Coolidge v. New Hampshire, where the state endeavored to justify the seizure of the automobiles in plain view and their subsequent search at the police station. The cars were obviously in plain view, but whether or not they were evidence of a crime remained uncertain until after the interiors were swept and examined microscopically. The incriminating nature of the car was not therefore immediately apparent. The court hence held that the police, in seizing two automobiles parked in plain view on the defendant's driveway in the course of arresting the defendant, violated the constitutional right of the accused and accordingly, particles of gunpowder that had been subsequently found in vacuum sweepings from one of the cars could not be introduced in evidence against the defendant. 10. Arizona v. Hicks is equally illustrative. Hicks fired a bullet into the floor of his apartment. The bullet struck a person in the room apartment directly below. Responding police officers entered the apartment of Hicks and though they did not find him, they found 3 weapons and a stocking cap mask. An officer noticed 2 sets of expensive stereo equipment, which seemed out of place inside the squalid, run-down and ill-appointed 4-room apartment and suspected that the stereo components were stolen. He recorded their serial numbers. In the process, he had to move a turntable which was in the way. That they were stolen and taken during an armed robbery were later confirmed. Hicks was subsequently arrested. The state trial court and the Arizona Court of Appeals granted the motion to suppress all the evidence seized on the ground that the seizure was unconstitutional. When the Arizona Supreme Court denied review, the United States Supreme Court accepted the prosecutor's request for a hearing. In Arizona v. Hicks, the Supreme Court first ruled that the warrantless entry by the officers, under the exigent circumstances exception to the warrant requirement, was valid. Next, the court held that the mere recording of serial numbers of appliances and equipment did not constitute a seizure under the Constitution, since it did not meaningfully interfere with the respondent's possessory interest in either the numbers recorded or the stereo equipment. However, the moving of the equipment was a search separate from the search that was the lawful objective of entering the apartment. That the items were stolen were not immediately apparent and that there exists no separate justification for moving the equipment. The inadvertence requirement under the plain view doctrine. 1. Horton v. California, one of the leading American decisions on the plain view doctrine, is enlightening. In this case, a California police officer executed a search warrant only for the proceeds of the crime of robbery. He did not find stolen property in the premises, but in the course of his search, he did find weapons in plain view which he seized. During the trial, the accused moved to suppress the evidence as to the weapons on the ground that the weapons were not discovered inadvertently but on purpose and their search and seizure were not included in the warrant. The trial court refused and the accused was convicted of robbery. The California Court of Appeals affirmed. The U.S. Supreme Court held in the case that the Constitution does not require that the discovery of the evidence be inadvertent because this element is not a necessary condition of a warrantless seizure of things in plain view even if inadvertence have been mentioned as a characteristic in other legitimate plain view seizures. Accordingly, Justice Stewart's analysis of the plain view doctrine in Coolidge v. New Hampshire, where he declared that there must be an element of inadvertence, did not command a majority, and a plurality of the court has since made clear that the discussion is not a binding precedent. The suggestion that the inadvertence requirement is necessary to prevent the police from conducting general searches, or from converting specific warrants into general warrants, is not persuasive because that interest is already served by the requirements that no warrant issue unless it particularly describes the place to be searched and the persons or things to be seized. 2. The inadvertence requirement, like in Coolidge, appears however, to be the consistent norm in Philippine jurisprudence. The requirement of inadvertence means that the officer must not have known in advance of the location of the evidence and discovery is not anticipated. Emphatically, it was ruled that the plain view doctrine does not apply where the police officers did not just accidentally discover the evidence but actually searched for it. 3. In one case, the court gave no credence to the claim that the plain view doctrine applies. In 1996 the accused, Valorizo, was charged with violation of Presidential Decree No. 1866 for illegal possession of firearms and later was convicted by the trial court. On appeal, the Court of Appeals affirmed the conviction. On petition for review, the Supreme Court affirmed the decision of the Court of Appeals. The subsequent motion for reconsideration was denied by the court with finality. Undaunted, the accused implored the court through a letter appeal to once more take a contemplative reflection and deliberation on the case, focusing on his breached constitutional rights against unreasonable search and seizure. The Office of the Solicitor General filed a manifestation in which it changed its previous position on the case and instead recommended the acquittal of the accused. The OSG claimed that after a second look at the evidence presented, the OSG considers the testimonies of the witnesses for the defense more credible and concluded that the subject was obtained by the police officers in violation of his constitutional right against illegal search and seizure, and should thus be excluded from the evidence for the prosecution. After considering anew arguments through the letter appeal, together with the OSG's position recommending his acquittal, and that substantial rights must ultimately reign supreme over technicalities, the court was swayed to reconsider. The court found that the accused was arrested by virtue of a warrant of arrest allegedly for kidnapping with ransom. At that time, he was sleeping inside the boarding house of his children. He was awakened by the arresting officers who were heavily armed. They pulled him out of the room, placed him beside the faucet outside the room and tied his hands and then put him under the care of a police officer. The other police officers remained inside the room and ransacked the locked cabinet where they found the subject firearm and ammunition. With such discovery, the accused was charged with illegal possession of firearm and ammunition. From the foregoing narration of facts, the court concluded that the arresting officers served the warrant of arrest without any resistance from the accused. They placed him immediately under their control by pulling him out of the bed, and bringing him out of the room with his hands tied. To be sure, the cabinet which was locked and forcibly opened could no longer be considered as an area within his immediate control because there was no way for him to take any weapon or to destroy any evidence that could be used against him. The arresting officers would have been justified in searching the person of the accused as well as the tables or drawers in front of him, for any concealed weapon that might be used against the former. But under the circumstances obtaining, there was no comparable justification to search through all the desk drawers and cabinets or the other closed or concealed areas in that room itself. The court amplified. It is worthy to note that the purpose of the exception, warrantless search as an incident to a lawful arrest, is to protect the arresting officer from being harmed by the person arrested, who might be armed with a concealed weapon, and to prevent the latter from destroying evidence within reach. The exception, therefore, should not be strained beyond what is needed to serve its purpose. In the case before us, search was made in the locked cabinet which cannot be said to have been within Valorizo's immediate control. Thus, the search exceeded the bounds of what may be considered as an incident to a lawful arrest. Nor can the warrantless search in this case be justified under the plain view doctrine. The plain view doctrine may not be used to launch unbridled searches and indiscriminate seizures or to extend a general exploratory search made solely to find evidence of defendant's guilt. The doctrine is usually applied where a police officer is not searching for evidence against the accused, but nonetheless inadvertently comes across an incriminating object. 30. What the plain view cases have in common is that the police officer in each of them had a prior justification for an intrusion in the course of which he came inadvertently across a piece of evidence incriminating the accused. The doctrine serves to supplement the prior justification, whether it be a warrant for another object, hot pursuit, search incident to lawful arrest, or some other legitimate reason for being present unconnected with a search directed against the accused, and permits the warrantless seizure. Of course, the extension of the original justification is legitimate only where it is immediately apparent to the police that they have evidence before them. The plain view doctrine may not be used to extend a general exploratory search from one object to another until something incriminating at last emerges. Indeed, the police officers were inside the boarding house of Valorizo's children, because they were supposed to serve a warrant of arrest issued against Valorizo. In other words, the police officers had a prior justification for the intrusion. Consequently, any evidence that they would inadvertently discover may be used against Valorizo. However, in this case, the police officers did not just accidentally discover the subject firearm and ammunition, they actually searched for evidence against Valorizo. Clearly, the search made was illegal, a violation of Valorizo's right against unreasonable search and seizure. Consequently, the evidence obtained in violation of said right is inadmissible in evidence against him. Terry searches or stop and frisk, History of the Doctrine, Bar 1995, 2003. 1. Suppose a police officer is on a routine patrol duty and he observes two people outside a variety store. Both his experience and training tell him that their acts are consistent with acts of people with criminal designs, although he has no concrete facts showing probable cause that a crime has been committed or that it is actually being committed. He knows that mere suspicion is not sufficient to make a valid arrest, but his instincts honed by years of experience in the streets tell him something untoward is imminent. May he briefly stop the persons, ask them questions and engage in a protective search for a concealed weapon short of a full-scale arrest. The Supreme Court of the United States addressed a similar situation in 1968 in the landmark case of Terry v. Ohio, 392 U.S. 1. 2. In the middle of the afternoon of October 31, 1963, veteran police officer Martin McFadden was in his usual beat in downtown Cleveland, a place he had covered for 30 years as member of the Cleveland police force. McFadden saw two unknown men who later were identified as Terry and Chilton, and who by their acts appeared to him to be engaged in an elaborate yet casual reconnaissance of a store. At one point, a third man, later on identified as Katz, came to confer with the first two, then disappeared and then rejoined the other two. Suspecting them to be armed, and fearing that the three were preparing to rob the store, McFadden approached the men, identified himself as a police officer and asked them to identify themselves. When they simply mumbled an answer and did not get a clear and audible response, he patted down the outer garment of Terry and felt a gun in his pocket and removed the same. A gun was also recovered from Chilton. Terry was subsequently convicted for carrying a concealed weapon. The Ohio Court of Appeals affirmed the conviction, and the Ohio Supreme Court declined to hear the case, claiming that no substantial constitutional question was involved. The U.S. Supreme Court then took cognizance of the case. In the Supreme Court, Terry contended that there existed no probable cause for his arrest, that since the stop was an arrest and that the frisk was a search under America's Fourth Amendment, freedom from unreasonable searches and seizures, probable cause is required. The argument was rejected by the Supreme Court. Speaking for the court, Chief Justice Warren declared, "The crux of this case, however, is not the propriety of Officer McFadden's taking steps to investigate petitioner's suspicious behavior, but rather, whether there was justification for McFadden's invasion of Terry's personal security by searching him for weapons in the course of that investigation. We are now concerned with more than the governmental interest in investigating crime. In addition, there is the more immediate interest of the police officer in taking steps to assure himself that the person with whom he is dealing is not armed with a weapon that could unexpectedly and fatally be used against him. Certainly, it would be unreasonable to require that police officers take unnecessary risks in the performance of their duties." The court held that the acts of Officer McFadden were acts which a reasonably prudent man would have done in believing that Terry was armed and that he presented a threat to the officer's safety while he was investigating his suspicious behavior. The actions of Terry and Chilton were consistent with McFadden's hypothesis that these men were contemplating a daylight robbery which reasonably would have been carried out with a deadly weapon. Nothing in their conduct from the time he first noticed them until the time he confronted them and identified himself as a police officer gave him sufficient reason to negate that hypothesis. Mumbling an unclear response to the officer's distinct question did nothing to clear up the suspicion. The record, observed the court, evidences the tempered act of a policeman who in the course of an investigation had to make a quick decision as to how to protect himself and others from possible danger, and he took limited steps to do so. The court likewise noted that Officer McFadden's actions were not invasive and overly intrusive. He patted down the outer clothing of Terry and his two companions. He did not place his hands in their pockets or under the outer surface of their garments until he had felt weapons, and then he merely reached for and removed the guns. He never did invade Cat's person beyond the outer surfaces of his clothes, since he discovered nothing in his pat-down which might have been a weapon. Officer McFadden confined his search strictly to what was minimally necessary to learn whether the men were armed and to disarm them once he discovered the weapons. He did not conduct a general exploratory search for whatever evidence of criminal activity he might find. The court concluded that the revolver seized from Terry was properly admitted in evidence against him. At the time he seized Petitioner and searched him for weapons, Officer McFadden had reasonable grounds to believe that Petitioner was armed and dangerous, and it was necessary for the protection of himself and others to take swift measures to discover the true facts and neutralize the threat of harm if it materialized. The policeman carefully restricted his search to what was appropriate to the discovery of the particular items which he sought. The court held that where a police officer observes unusual conduct which leads him reasonably to conclude in the light of his experience that criminal activity may be afoot and that the persons with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior he identifies himself as a policeman and makes reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or others' safety, he is entitled for the protection of himself and others in the area to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. Such a search is a reasonable search and any weapons seized may properly be introduced in evidence against the person from whom they were taken. Justice Harlan, who wrote a concurring opinion, explained, "The facts of this case are illustrative of a proper stop and an incident frisk. Officer McFadden had no probable cause to arrest Terry for anything, but he had observed circumstances that would reasonably lead an experienced, prudent policeman to suspect that Terry was about to engage in burglary or robbery. His justifiable suspicion afforded a proper constitutional basis for accosting Terry, restraining his liberty of movement briefly, and addressing questions to him, and Officer McFadden did so. I would affirm this conviction for what I believe to be the same reasons the court relies on. I would, however, make explicit what I think is implicit in affirmance on the present facts. Officer McFadden's right to interrupt Terry's freedom of movement and invade his privacy arose only because circumstances warranted forcing an encounter with Terry in an effort to prevent or investigate a crime. Once that forced encounter was justified, however, the officer's right to take suitable measures for his own safety followed automatically. Summary of the Terry Doctrine. 1. The Terry Doctrine is of two parts, the stop and the frisk. A valid stop by an officer requires that he has a reasonable and articulable belief that criminal activity has happened or is about to happen. The frisk made after the stop must be done because of a reasonable belief that the person stopped is in possession of a weapon that will pose a danger to the officer and others. The frisk must be a mere pat-down outside the person's outer garment and not unreasonably intrusive. 2. The gist of the ruling in Terry considered as constitutionally permissible a stop and frisk despite the lack of a probable cause to make a full-scale arrest. While conceding that the search was a search as defined by the Constitution, it did not agree with the accused that the constitutional prohibition on unreasonable searches and seizures was violated when he was stopped and frisked without a probable cause. The test of the conduct of an officer under similar circumstances was not the existence of probable cause because no full arrest is made. The test instead was reasonable belief, called a genuine reason in a Philippine decision, because of the important interest in protecting the safety of police officers, The court held that a law enforcement officer has the authority to stop someone and do a quick surface search of their outer clothing for weapons. This is allowed if the officer has a reasonable belief based on a genuine reason and in the light of the officer's experience and the surrounding circumstances, that a crime has either taken place or is about to take place and the person to be stopped is armed and dangerous. This reasonable suspicion must be based on specific and articulable facts and not merely upon the officer's bare suspicion or hunch. Terry emphasized that a reasonable belief for making a stop may also be followed by a frisk which is equally reasonable, which means it should not be broader than is necessary to find weapons in the person briefly stopped. The ruling that probable cause is not required in a stop-and-frisk situation is Terry's significant contribution to jurisprudence. 3. Terry v. Ohio did not justify every stop. Before an officer stops a private citizen in the street, the act must be justified by concrete facts pointing at the least towards a possible criminal activity, where no crime is still apparent to the officer. Terry calls these concrete facts as the specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant that intrusion. A mere deep suspicion by an experienced officer that criminal activity could take place is not sufficient for the application of the Terry doctrine. He must support his conclusion by particularizing the acts that led to his conclusion. 4. In Esquilo v. People, GR number 180 2010, August 25, 2010, the police officers were on a surveillance operation as part of their law enforcement efforts when Paul Cruz saw petitioner placing a plastic sachet containing white crystalline substance into her cigarette case. Given his training as a law enforcement officer, it was instinctive on his part to be drawn to curiosity and to approach her. That petitioner reacted by attempting to flee after he introduced himself as a police officer and inquired about the contents of the plastic sachet all the more pricked his curiosity. Citing previous jurisprudence, the court in Esquilo elucidated on what includes stop-and-frisk operation and how it is to be carried out. The court declared that the operation is the act of a police officer to stop a citizen on the street, interrogate him, and pat him for weapons or contraband. The police officer should properly introduce himself and make initial inquiries, approach and restrain a person who manifests unusual and suspicious conduct, in order to check the latter's outer clothing for possibly concealed weapons. The apprehending police officer must have a genuine reason, in accordance with the police officer's experience and the surrounding conditions, to warrant the belief that the person to be held has weapons, or contraband, concealed about him. 5. A reading of numerous jurisprudence discloses that the stop-and-frisk principle serves a dual purpose: 1. The general interest of effective crime prevention and detection, and 2. The safety of the police officer to take steps to assure himself that the person with whom he deals is not armed with a deadly weapon that could be used against him. This principle of stop-and-frisk search was invoked by the court in a case where policemen chanced upon the accused who had reddish eyes, walking in a swaying manner, and who appeared to be high on drugs. Thus, the validity of the search as akin to a stop-and-frisk was upheld. The court also found justifiable reason to stop and frisk the accused after considering the following circumstances: the drunken actuations of the accused and his companions, the fact that his companions fled when they saw the policeman, and the fact that the peace officers were precisely on an intelligence mission to verify reports that armed persons were roaming the vicinity. What is, therefore, essential is that a genuine reason must exist, in light of the police officer's experience and surrounding conditions, to warrant the belief that the person who manifests unusual suspicious conduct has weapons or contraband concealed about him. Such a stop-and-frisk practice serves a dual purpose: 1. The general interest of effective crime prevention and detection, which underlies the recognition that a police officer may, under appropriate circumstances and in an appropriate manner, approach a person for purposes of investigating possible criminal behavior even without probable cause, and 2. The more pressing interest of safety and self-preservation which permit the police officer to take steps to assure himself that the person with whom he deals is not armed with a deadly weapon that could unexpectedly and fatally be used against the police officer. To repeat, a stop-and-frisk situation is limited to the person's outer clothing, and should be grounded upon a genuine reason, in light of the police officer's experience and surrounding conditions, to warrant the belief that the person detained has weapons concealed about him. Terry searching the search incident to a lawful arrest. 1. A Terry search or a stop-and-frisk is not to be confused with a search incident to a lawful arrest. Although they result in a warrantless search, they differ in terms of the requisite quantum of proof before they may be validly effected and in their allowable scope. 2. A Terry stop is not a full arrest. A Terry doctrine as originally formulated, does not require a probable cause and the person is not under a full-scale arrest but under a mere brief, investigative stop followed by a surface, non-intrusive pat-down of one's outer garments to determine the presence of weapons. A search incident to a lawful arrest presupposes the existence of a probable cause for the arrest, where the person is taken under the custody of the arresting officer. The search is of the person and the area within his control. It is thus more intrusive and is conducted not only for the purpose of finding weapons but also for the purpose of searching for evidence, any fruit of a crime or of things which may provide the person arrested with the means of escape. 3. A Terry stop and frisk has a limited scope compared to a full-scale arrest and search. The Terry doctrine therefore, is not judged by the more stringent requirement of probable cause which conceitedly applies only to an arrest and a search. What applies in a Terry stop and frisk is the reasonableness of the act of the officer. This reasonable standard, while not sufficient to validate an arrest or a search, justifies a Terry stop and frisk. As a general rule, a search and seizure must be carried through with judicial warrant, otherwise, such search and seizure constitutes derogation of a constitutional right. The Constitution does not provide a blanket prohibition against all searches and seizures, rather, the fundamental protection accorded by the Search and Seizure Clause is that, between persons and the police, there must stand the protective authority of a magistrate clothed with the power to issue or refuse such search warrant. The responsibilities of the magistrate do not end with the granting of the warrant, but extends to the custody of the articles seized. Where the articles seized have already been found not to be the subject of the offense and the purpose of presenting them as evidence is no longer served, there is no justification for severely curtailing the rights of a person to his property. Bond to ensure the return of the seized items. An order requiring the owner of seized property to file a bond to ensure the return of the seized items should the Department of Justice find probable cause against it has no basis in law. Consented searches. 1. The consent to a warrantless search must be voluntary, that is, it must be unequivocal, specific, and intelligently given, uncontaminated by any duress or coercion. Consent to a search is not to be lightly inferred, but must be shown by clear and convincing evidence. It is the state which has the burden of proving, by clear and positive testimony, that the necessary consent was obtained and that it was freely and voluntarily given. 2. Jurisprudence requires that in case of consented searches or waiver of the constitutional guarantee against obtrusive searches, it is fundamental that to constitute a waiver, it must first appear that, 1. The right exists, 2. The person involved had knowledge, either actual or constructive, of the existence of such right, and, 3. The said person had an actual intention to relinquish the right. A peaceful submission to a search or seizure is not a consent or an invitation thereto, but is merely a demonstration of regard for the supremacy of the law. Effect of an illegal search and seizure, fruit of the poisonous tree doctrine, Bar 2005. 1. The effect of an illegal search and seizure is expressed in the following constitutional provision. Section 3, 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. 2. A search warrant illegally obtained or secured or which is issued in violation of the Constitution or the rules may be quashed through the proper motion as in a motion to quash the search warrant. Also, when evidence is illegally obtained, a motion to suppress the evidence is in order. 3. The general rule is that all searches and seizures made without a warrant are invalid. The illegality of a search and a seizure occurs not only from the failure to obtain a warrant when required but also from the failure to comply with the procedures for obtaining a warrant and in the execution of the same. Such failure will result in the application of the exclusionary rule. The exclusionary rule prevents, upon proper motion or objection, the admission of evidence illegally obtained. Thus, the most important effect of an illegal search and seizure is the exclusion of the evidence obtained from being used against the person whose rights were violated by the search, the evidence being the proverbial and jurisprudential fruit of the poisonous tree. The violation of an individual's rights also inevitably result into civil, criminal and administrative charges against the officer responsible for the violation. Bar 2005. 4. The prior rule embodied in Mancado v. People's Court, held that the unconstitutionality of the searches and seizures does not affect the admissibility of the evidence obtained because the criminal should not be allowed to go free because the constable has blundered. The non-exclusionary rule in Mancado was anchored on the theory that the citizen is protected by other provisions of the laws and has means of redress other than the exclusion of evidence unlawfully obtained, such as actions for damages against the erring officers and the person who procured the warrant. This theory, however, was subsequently rejected in Stonehill v. Diacono. As Stonehill declared, the non-inclusionary rule is contrary, not only to the letter, but also, to the spirit of the constitutional injunction against unreasonable searches and seizures. 30. We hold, therefore, that the doctrine adopted in the Mancado case must be, as it is hereby, abandoned. Civil damages, criminal liability. 1. The proceedings under Rule 126 do not provide for the filing of counterclaims for damages against those who may have improperly sought the issuance of the search warrant. However, these aggrieved have the right to seek damages, if the circumstances warranted, by separate civil action for the wrong inflicted on them by an improperly obtained or enforced search warrant. 2. There is civil liability based on the concept of an independent civil action for violation of a person's right to be secure in his persons, house, papers, and effects against unreasonable searches and seizures, Article 32(9), Civil Code of the Philippines. This liability is separate and distinct from any criminal liability that may arise from the revised penal code, like a. Violation of domicile, Article 128, Revised Penal Code, b. Search warrant maliciously obtained and abuse in the service of those legally obtained, Article 129, Revised Penal Code, or possibly, c. Searching domicile without witnesses, Article 130, Revised Penal Code. Authority of the Executive Judge and Vice Executive Judge re-search warrants in Manila and Quezon City. 1. AM No. 99-2009 SC dated January 25, 2000 authorizes the executive judges of the RTCs of Manila and Quezon City to act on all applications for search warrants involving heinous crimes, illegal gambling, dangerous drugs and illegal possession of firearms on application filed by the Plug and Play, NBI, Presidential Anti-Organized Crime Task Force, and Reaction Against Crime Task Force. The application shall be personally endorsed by the heads of said agencies, for the search of places to be particularly described therein and the seizure of property or things as prescribed in the rules of court. The warrants issued may be served in places outside the territorial jurisdiction of said courts. 2. Although AM No. 99-2009 SC provides a personal endorsement of the application by the heads of the agencies mentioned, it was held that nothing in the rule prohibits such heads from delegating the ministerial duty of endorsing the application for search warrants to their assistant heads.